Hi, everyone. Thanks for joining us tonight. This is the first episode of our mini webinar series. Tonight, we're doing it on trust. We have some future ones coming up. We're going to do a deep dive into all of the different estate planning documents. So tonight is trust. Then we're doing wills and durable powers of attorney and healthcare surrogates. I'm not sure if it's in that order, but we will be covering all of those different documents each week in the month of May. So hopefully you can join us for those other ones. And welcome, Jenny. Jenny Lamb is our amazing marketing director. She helps put all these things together.
Hi, everyone. Thanks for joining tonight's webinar.
Okay, so I'm going to give it just a couple of seconds. We had a lot of people sign up, so I'm going to see if anybody else hops in, but we won't wait very long at all. I guess I can just go through some of our slides here before we jump into the substance of it. There we go. Okay, so I'm Samantha Fitzgerald. Welcome again. Our firm is SJF Law Group. We're located in Plantation, Florida. I've been in business since 2011. All we do is trust and estate work. So we do estate planning, we do probate and trust administration. And that's our specialty here. So tonight we're talking about trusts, and we're going to do a real deep dive into them. And at the end, towards the end of the seminar, I'm actually going to give a handout, which is a sample trust document so that you can actually see one. We have the chat feature available, so please don't hesitate to ask questions at any time. Pop it into the chat there. We love your questions. It makes it more interactive, and it's always good to just get off of me talking. So the questions make it a lot more interesting, and hopefully give you some better clarity as to what we are talking about. Okay, so what is a trust? Trusts are really difficult for a lot of people to wrap their heads around. It's just a document that is going to dispose of your assets, typically upon death, although there are many different types of trusts. But typically a trust is just a document, and it's going to say who gets your estate when you die and who you are appointing to be in charge. So it's very similar in that respect to a will. It's a document that says who gets what and who's in charge. There's lots of different ways you can actually use a trust. So a trust, first of all, can be revocable or irrevocable. Revocable just means that you can modify it, change it, you can revoke it, say you don't want it anymore. It's very, very flexible. This is the most common type of trust that we use in estate planning. Sometimes it's referred to as a will substitute, but that's not really accurate. Then there's irrevocable trusts. So it's really just those two types of trusts: irrevocable, revocable. Irrevocable trusts are like it sounds. Theoretically, they are irrevocable. You can't change them, modify them, or do away with them. But there's always exceptions to all of that. There's lots of different ways that you can actually modify or revoke an irrevocable trust, but you just can't do it without somebody else's participation in that process. So with a revocable trust, the creator of that trust can do away with it or revoke it, whereas an irrevocable trust is a little bit more complicated, and it's going to require somebody's consent, either a beneficiary or a trustee or both, or it's going to require court approval to be able to modify or revoke it. Tonight, we're mostly talking about revocable trusts, although happy to answer any questions about irrevocable trusts. So some basic terms related to trust. We've got the grantor or the settlor. That's the person that creates the trust. Oftentimes, when you are doing a revocable trust, you have one person wearing lots of different hats. But you could have somebody that creates a trust, so they're the grantor or settlor, and somebody else is all the other things. They're just creating the trust for somebody else's benefit. Then we've got the trustee. The trustee is the person in charge of the trust. They are going to follow the terms of the trust that's created by the grantor or settlor. The beneficiary is the person that benefits from the trust. So the trustee is not necessarily a beneficiary. They are the person that is following the terms of the trust for the benefit of the beneficiary. And there could be multiple of all these different things. There could be multiple trustees at one time. There's also going to be hopefully successor trustees designated in the document. And there can be multiple beneficiaries at the same time, or there might be one beneficiary. So when you create your own trust, initially you are the grantor, you're typically the trustee, and you are the beneficiary. You wear all of those hats at the same time. If you became incapacitated, you'll still be the grantor, the settlor, and the beneficiary, but somebody else will step in and become the trustee, managing the trust and the assets that are in the trust for your benefit then. Then there's this person called the trust protector. And this is kind of a flexible tool or option. A trust protector is somebody that gets appointed. They're not a trustee, but they have some sort of role or power in the trust to do something that maybe the trustee can't do. So it's common to use trust protectors when we do irrevocable trust, because we'll give that trust protector the power perhaps to modify the trust. So it's a way to build in some flexibility. You can really give them the ability to do anything. So if you need, they could be like a tiebreaker. So if you have two trustees, you have co-trustees, and you're concerned that they might not agree to something, the trust protector could be the tiebreaker. They might review financial records related to the trust to make sure that nobody's doing anything wrong. You could use the trust protector as a way to stay out of court. It's really whatever you can think up, you can write into the trust and give the trust protector some sort of power to do something. So those are the basic terms of the trust so that you understand what they are before we move on. So what is a testamentary trust? Testamentary trust is when there are trust provisions added into a will. So you don't have a separate trust document, you just add some trust provisions inside your will. So your will might say something like, I leave everything to my children upon my death, but if my children are under the age of 30, their share shall be held in trust by Bob Doe until they reach that time. And Bob is in charge of it. Bob acts as the trustee, and he's going to be in charge of the assets. So you've created a trust, but it's inside your will. So the way that assets get into a testamentary trust are through the will, through the probate administration. If you don't have a separate trust and you have minor children, if you do a will, 100%, you should at least put testamentary trust provisions in your will, because you never want to leave anything to a minor child. There's lots of reasons that we'll go through in a little while as to why you might want to leave something, some sort of devise in a trust for beneficiaries, even if they are not minor kids. So it can't hurt to have testamentary trust provisions in a will all the time. But it is a little bit better to have a completely separate trust document. But a testamentary trust is better than nothing. You typically can't designate this type of trust as beneficiary on financial accounts, and it definitely cannot own, like you could not retitle your real property into a testamentary trust, because this type of trust doesn't exist until somebody dies, and then the will is admitted to the probate court. Okay. Feel free to ask questions anytime. So how are trusts taxed? What happens with taxes? So first of all, if you're alive and you have a revocable trust, it does not need its own tax ID, which is called an EIN, Employer Identification Number. You don't need a separate tax ID. If you are going to retitle your financial accounts into the trust, you're just going to use your social security number like you always did in the past. It doesn't have a separate tax ID because it does not need to file tax returns. While it's revocable, it doesn't exist for tax purposes at all. The IRS completely ignores it while it's revocable. If you create an irrevocable trust or you die and your trust then becomes irrevocable, then it's a taxable entity. It's kind of like a corporation, let's say. So it becomes this tax entity. It does need its own tax ID at that time. And if you've ever served in the capacity as trustee, you might have seen that, as you're trying to manage an account that's titled in a trust, one day that account was in mom or dad's name, perhaps, or your spouse's name, and you managed it like normal. No separate tax return needed. And all of a sudden that person dies and your financial advisor is saying, we need an EIN. So you need that EIN immediately for that trust because it is now kind of created this separate identity apart from the original grantor. So all irrevocable trusts will typically have a tax ID, and they may or may not file tax returns. And that's because there's this concept called grantor trust. So all revocable trusts are grantor trusts. Grantor trust means that the person who created it, the grantor, is treated as the owner of either the principal portion of the trust or the income portion of the trust. So for tax purposes, we're talking about the income portion of the trust. And if the grantor is treated as owning the income portion, then they actually report the income on their own personal tax return as if the trust didn't exist. So this, this concept can get a little complicated, but this is definitely a concept that we use in estate tax planning. It's a very common thing to make an irrevocable trust a grantor trust because we typically want the grantor to report the income on their personal tax return, and we don't want to file a separate tax return for the trust, or we don't want the trust itself to at least report the income or pay any tax. So there's lots of different ways you can create a grantor trust, and it's usually by including some sort of retained power in the trust by the grantor. So one common power is the ability to swap assets. So if I have a piece of real property in the trust, but I've retained the right to take that property out and instead put a different property in there or put cash in there instead, I've retained a sufficient right to over the trust so that it's going to be treated as mine for income tax purposes, in which case I will report all the income on my personal tax return. So taxes can get very, very tricky with trusts. Trust income, if it does have income, if the income is retained inside the trust and it's not a grantor trust, trusts pay a fairly high rate of tax because they hit the highest tax bracket pretty fast. It's about $13,000 or so. They hit the highest tax bracket. So they're going to be at that really high tax bracket quickly as compared to an individual. But if the income is distributed out of the trust to the beneficiary, the trust is a flow-through type of entity. So that income actually flows over to the beneficiary on a K-1 form, and the beneficiary picks up the income on their personal tax return. So There's lots of ways to plan with trusts and taxes. And you definitely want to have a really good CPA that understands this. And the trust files, it's called a Form 1041, different from a Form 1040. And they are not super simple. So you want to make sure that you're working with somebody that understands 1041 returns and the filing of them. Trusts must file on a calendar year basis, just like people do. So from January to December is their tax year. However, if somebody died and they had a trust, there is a way where you can choose a fiscal year for that trust. Um, it's estates, so probate administrations, estates can have a fiscal year, but trusts cannot. But there is a way where you can combine both the estate return and the trust return, we're talking income tax returns, not estate tax returns. You can combine them together, and that's kind of like a backdoor way of how you can choose a fiscal year for your trust return. So, kind of make a mental note of that if you're ever in that situation. Okay. Limitations of trust. So trusts are not perfect, but they're close to perfect. They're really, really good planning tools. But some of the limitations of trust. There is no creditor protection for the grantor or the settlor with a revocable trust. We have tons of clients that come into the office and they want to have a trust and they want to protect their assets from creditors. And it's a big misconception. You cannot create a trust, put your assets into it, and keep those assets away from creditors, at least not in Florida. Florida does not allow self settled trusts, which is what that's called. Other states do have domestic asset protection trusts. They're self settled trusts, meaning that you created it for yourself and you want to keep those assets away from your creditors. So can't do it in Florida. Even if you did it outside the state of Florida, it's not as simple as everybody thinks. It's pretty complex and it's a bit restrictive. So it's usually not what people are looking for, but they do think that that's something that trusts do, and it doesn't. Trusts still require administration. There's no magic wand that when somebody dies and they have a trust, so they did all their planning, no assets are going to pass through a probate administration. It doesn't mean that it magically just happens, with the blink of an eye. There's still this administration period. So your trustee still has to gather your assets. They, probably need to get a tax ID number. They might need to close accounts down, collect accounts, move things into a new account under the name of the trust. There's paperwork and documentation that they have to prepare and sign, and they absolutely should be hiring an attorney to guide them through this process and provide them with legal advice. So it's not a magical thing that happens and it avoids everything. But it is much better than going through a probate administration. For sure. It's a lot faster, it's less expensive, um, and you have much less of a likelihood of litigation ensuing if you are not already in the court system. So it's still better. It's not magical, but it is a lot better than going through a probate administration. So it definitely has its benefits. No cryptocurrency. Well, that is just to kind of highlight that there are restrictions on what the trust can invest in. It's not limited to just cryptocurrency, but that is definitely a good example of something that a trustee would not want to invest in because the trustee is a fiduciary held to a very high standard of care. They're subject to the prudent investor rules. So they have to be really careful because they are being entrusted with this money for somebody else's benefit for the beneficiary. So you can't um, haphazardly invest in things You have to be careful, and you have to also look at both the interests of the principal beneficiaries and the income beneficiaries. So somebody who may benefit from appreciation of assets compared to somebody who may benefit only from the income. You may have somebody that only has a right to income, in which case you can't just invest in something that produces zero income. But eventually somebody's going to get the remainder of that trust, the principal, and you can't invest in something that's only kicking off tons of income and will never appreciate. So the trustee has a big responsibility to invest prudently in investments that are going to benefit everyone to the extent possible. So it's a big responsibility. If you are ever serving as trustee, you can transfer over your investment responsibility to an investment advisor. There's a method of doing that. You want to do it in writing so that you put all of the responsibility on them, and you take it off yourself. So that is definitely good. Unless you are a professional investment advisor, this can definitely be a very good strategy to do. Um, so other limitations of trust that sometimes couples don't understand when we talk about, well, I want to leave something in trust for my spouse because I want to be able to control the ultimate disposition of that asset, which is a benefit of having a trust, but it also comes with some limitations because that spouse can't just spend all the money however they want, depending on how the terms of the trust are written. They also have to provide annual accountings to the remainder beneficiaries, and sometimes they don't want to do that. So those are just things that people need to understand, that when it's in a trust structure, it is in some sort of legal structure. It's not the same as giving something outright to somebody for them to own 100% by themselves. No questions so far? Okay. Benefits of trust. There are lots of benefits of trust. So, although you can't protect yourself from your creditors, the money you leave to your beneficiaries in trust is protected from the beneficiary's creditors. So if they get sued or they need to file bankruptcy, those trust assets are protected. Of course, it's going to depend on how the trust is written, but if the trust is written properly, then it's going to be protected from their creditors. It's also protected from their spouses. Again, depends on how strong the language is, but the assets in a trust should not be available to that beneficiary spouse in the event of divorce. If the beneficiary is incapacitated and they can't act on their own behalf, then there's going to be a successor trustee that steps in and can take over managing that trust for the benefit of the beneficiary. So you have that built-in protection for somebody else to manage the assets if they're incapacitated, or if they are disabled, if they are receiving some sort of need-based government benefit, then will definitely depend on the terms, the language in the trust. But in the trust that we do, we include supplemental needs provisions, trust provisions in all of our trusts, just in case. So supplemental needs trust or a special needs trust is a special type of trust that allows assets to be held for the benefit of a disabled person without risking loss of their government benefits. This is very, very important. If you have anybody in your life that has a disability, it is really important that you never leave them anything outright, or even in a regular trust. It needs to go into a special or a supplemental needs trust. Very, very important. They will lose their benefits, and that could be disastrous. One of the huge benefits is Medicaid, which is their health insurance, and that's very, very important to retain. There are some tax benefits to trusts. We talked about the non-benefits before, but where there's tax benefits is typically with estate tax planning. So you can make irrevocable gifts or devises into a trust. And once it's in that irrevocable trust, it's going to be locked in there. So if if you're wealthy and you have a large estate and you make $1 million gift into a trust, and 15 years from now that $1 million turns into $10 million, well, that is forever out of your estate. It's forever out of the beneficiary's estate. It has grown tax-free in a sense, where it's not going to be subject to additional estate tax. So trusts are heavily used in estate tax planning. Flexibility. Oh boy, trusts are really flexible. We talked a little earlier about the trust protector. Um, there's we can write all sorts of things into trust. We can really use them to produce all sorts of different outcomes. So much easier than if something were to pass through a probate administration, we're in court, we're restricted. Sometimes, the judges can be difficult or the court process can be difficult. But in a probate administration under a will, it's not an ongoing thing. It's a finite period of time. Something goes through probate, it passes to a beneficiary and they get it. Or if it's a beneficiary designation, so you have somebody listed on your financial account, your life insurance, your retirement account, or maybe you did a ladybird deed so that your home is going to pass outside of probate. All those things pass outside of probate, but they pass directly to a person. There's zero flexibility there. It passes to them and that's it. Then they own it. They might be disabled. They might be incapacitated. They might have creditors. They might have judgments against them. They might be in the middle of getting a divorce. They might be in the middle of a bankruptcy. Or maybe they're fine right then and there, but a year later, some of those things are happening to them. There's zero flexibility there. It's finite, bam, done. With a trust, there's lots of flexibility that we can write into the trust, depending on how we want distributions made. Or we recently did one where we said that this person's significant other, not their spouse, but their significant other who was living with them, could remain in the home for a certain period of time. You can't do that with a probate administration or a ladybird deed or anything like that. So the trust, almost whatever you can think of, we can figure out a way to get it in there as long as it's legal. So it's very, very flexible. And because you're not before the court, not that people are doing things wrong, but there's not as much scrutiny. So it's just a lot easier to administer. Um, Trust help reduce litigation. So if you are, again, you're outside of the court system, it's less likely that somebody is going to file a lawsuit or start some sort of litigation. They would have to go to court, open up a brand new case and start a case that way. But a trust is privately administered. There's no court involvement typically. So issues between trustees and beneficiaries tend to get resolved outside of the court process because otherwise it's just too costly to go to court. So it definitely helps reduce litigation. It's very, very helpful with second marriages. So what a lot of people fail to consider is that when you own assets jointly, that asset passes to the survivor. And then when that survivor dies, passes to whoever their beneficiaries are, whether they have a will, a trust, or not, it's going to pass to their heirs or to their designated beneficiaries. So you have no control over that, and it may be a really bad result where your assets are passing over to your spouse's family when you didn't intend that. You might have intended to care for your spouse while they were alive financially, but that you intend when your spouse dies for those assets to go back to your heirs or beneficiaries. So a trust can be really, really helpful to help you provide for your spouse financially while making sure that ultimately the balance of the funds goes back to your children, or whomever you want it to go to. Sometimes people don't have children, but they still want their hard-earned money to go to their siblings or their nieces or nephews or to their favorite charity. So a trust can be very, very helpful with these things. There are certain rights that spouses have, people don't realize. And two of the big ones are homestead and elective share. So if you own a home, it does not matter if your spouse is not on the title and that you owned the home prior to the marriage. When you die, your spouse has rights to your primary residence. It is not the same. Death and divorce are not the same. So the instant you are married, your spouse has rights to your primary residence unless they waived their rights in writing. Elective share is the other big one, but this is something that they have to go actively elect. So if they don't, then they don't get it. But if they do make an elective share, then they can take 30% of everything that you own. It doesn't matter if it was in probate, in a trust, passed by beneficiary designation, it pretty much covers everything. So these are rights that spouses have that can be modified and tweaked in a trust. And especially if the couple agrees to doing things, the trust can be very, very flexible and make sure that everybody's covered, but that your assets ultimately go where they should go eventually. Do you need both a will and a trust? We get this question all the time. Well, if I'm doing a trust, I really want to do a trust, but if I do a trust, why do I need the will? They're completely different things. They're complementary to one another, but they are completely different. A will controls probate. That's it. That's its main job. As far as your assets are concerned, that's all it does. It controls probate and only probate. It has no control or effect on any assets that don't pass through probate. So assets, if you have a property with a ladybird deed, which is a life estate deed, it does not go through probate. It doesn't matter what your will says. If you have a financial account, whether that be a checking, savings, brokerage, life insurance policy, retirement account, 401k, IRA, any of that, if there's a designated beneficiary, it does not go through probate. Your will has no control on any of that. Your will only disposes of assets that are required to pass through probate. Now, the trust only controls assets that are actually in the trust. So they are two completely different mechanisms, let's say, or roads that you go down. Now, when you have a trust, your will is typically going to be what's called a pour over will. So if something slips through the cracks and it goes through the probate process, the will is going to pour those assets over into the trust. We want them connected because we don't want assets passing under the will directly to your beneficiaries because they might be incapacitated or disabled or dead or a minor child. So you want the will and the trust connected, but they are different and you definitely need both. You can have a will with no trust, but you shouldn't have a trust with no will. How is a will different from a trust? So I kind of explained some of it there. The will only controls probate. The trust only controls trust assets, but they do connect at some point. But in your will, that's where you're going to name guardians for your minor children. That's the main place where that will be. You can do a separate document designating them. There's also something called a pre-need guardian, um, where you could create that and actually put it on file with the clerk's office, the court clerk. But the most common place for people to designate guardians for their minor children is in their will. A will is also public record. It must be filed with the court. In fact, the court must actually, what we call, admit it to the probate court, which means the court reviews it, confirms that it's executed properly, and that the original was given to the court, and then they admit it to the probate court, and then it's a will. Prior to that time, it's almost nothing. It has no effect on anything. The people that you've designated in it as the personal representative are not the personal representative until they actually get appointed by the court, because they might not be qualified to serve as personal representative. So your original will is very, very important. The rule in Florida is, if you can't find your original will, meaning the one with the wet signature that you actually signed with a pen, if you can't find the original will, it's presumed that it was revoked. There is a process where you can prove it up if you have a copy of it, but it can be a difficult process. So you typically want to safeguard that original will and make sure you know where it is, and make sure that your beneficiaries or your personal representative know where to find it as well. So it's public record because it gets admitted to the court system, and anybody can go and get a copy of it. I can pull up anybody's will right now online for the most part, depending on the county and whether they have scanned online records. But if you couldn't do that, any person can go down to the courthouse and request a copy. They are public record. Um, the the probate process, where the will gets administered, is a court supervised process. It can be very challenging depending on the court, the county, the judge. Um, in Florida, probate cases are handled differently everywhere. Every county is different from the next county, but even within the county, some judges do things differently. They all have their own procedures. So you never know what's going to happen when you're in the court system, or what the court's going to require, what questions they might have, what documentation they might have. For instance, in Dade County, if you sell property that is valued over $600,000, you must supply the court with an actual appraisal from a certified appraiser, and then a copy of the closing statement after the sale. None of that happens in Broward County or Palm Beach County. So it's very different. So you really need to understand the different procedures from court to court. Even when you think you're complying with their procedures, the judge may still have questions. They may require that you come to a hearing. Right now in Broward County, it takes probably about 3 weeks to get a hearing. By the time you submit your petition to the court, it gets processed by the court clerk. It then goes before the judge, and the judge decides, I need to see you because I have questions. And then it takes another 2 weeks at least to get a hearing. So it's a very slow process to get anything done if you're in court. Whereas it's complete opposite. If you're in a trust, there's no court oversight, and things can move along very fast because the trustee has the power to do anything they need to do within reason, of course, under the trust. They have powers in the trust, and they can just move forward in the administration process. Trusts help avoid probate. Any asset that you have that is actually titled in the trust does not have to go through the probate process because it's owned in the trust. It offers protection from court challenges, as we discussed earlier. It's very unlikely that a beneficiary is going to, I shouldn't say very unlikely. There's plenty of trust litigation, right? But it's a deterrent that they have to go open up a brand new case, pay a filing fee, hire a lawyer to challenge some sort of thing under the trust. If they're a little bit unhappy about something, it's unlikely it's either going to go unresolved and too bad, so sad for them, or it's going to get resolved somehow between the trustee and the beneficiary, or two lawyers, but no court involvement. So it's not going to be very, very expensive and protracted litigation. Trusts help avoid guardianship for both minor kids and incapacitated adults. You leave something in a trust for a minor or incapacitated adult, and the trustee manages the money. So if you die and you have minor kids, they may have a court-appointed guardian for their person, somebody that they live with and it makes decisions for them, but all the money can be in a trust, and that is a much easier guardianship. You don't ever want to be under a guardianship with an adult person, which sometimes you can't avoid that, but you'd never want the money to be under the guardianship process because it is a mess. It's expensive. The assets go into a court restricted account. Anytime you need to get money out to pay for any expenses, you need a court order. So you need lawyers. It's very expensive and it's time consuming. Trusts are great for people that have a high net worth. They're confidential. They're not public record like wills are. So typically, wealthy individuals are going to want to use trusts. And they also help, of course, with estate tax planning. So I oftentimes explain a trust as being a crossover between a will and a corporation. It's a document like a will that's going to dispose of your assets at death. It says who gets what, and it says who's in charge, the trustee. So it's like they're the executor. But it's also this living entity while you're alive that can own assets, which a will can't do that. So it's kind of like a corporation. Sometimes it gets a tax ID number and it files tax returns like an entity. So it's this nice little crossover between the will and the corporation. Um, I think that's it for our slides. If you scan the QR code, it will take you to our social media, I believe, where we have lots of great information. As a reminder, we are continuing this mini webinar series throughout the month. Each week, we're going to go over a different document: wills, healthcare surrogates, durable powers of attorney. Jenny, if you could put the handout up, please. There we have a download. Give you some time. You can download. This is just a sample trust that I created because a lot of times, clients say, I can't wrap my head around what is this trust thing. So I created, it's a trust for a married couple, so husband and wife with 2 children. It presumes they have 2 children. So it has all the typical things that we would put into a very basic trust. Obviously, I didn't get complicated with distributions or anything. So this particular trust leaves everything to their kids, held in a lifetime trust. It designates trustees. It allows the kids to elect to be a co-trustee with whoever else is serving as trustee at the age of 25. And it allows the child to completely take over their trust at the age of 30. So it has special, we call supplemental needs provisions in there. It also has holdback provisions in there, which allow the trustee some flexibility to hold back a distribution in the event any bad things are happening with the beneficiaries, like they're getting sued or divorced, or had to file bankruptcy, or they're in a cult, or they're in prison, or they're doing drugs or alcohol. So a trust is very, very protective, lots of different reasons and ways. So sample document for you. Any questions at any time, of course, you are always welcome to reach out to us. All of our information is there. Catch us on social media. Thanks so much for attending, and we hope to see you at some future ones. Have a great evening, everyone.